Okay, we're going to continue with the program. We have our next topic, Heirs property. Mr. Casey Townsend, State Specialist, Land Retention and Wealth Building here at Kentucky State University.
Well, good afternoon, everybody. How's everybody doing? All right. Good, good. I hope y'all can hear me okay. So we're going to do a quick icebreaker. Before we dive into the presentation, we're going to do a icebreaker. But before we do that, I want to introduce myself again. My name is Casey Townsend. I am the Land Retention and Wealth Development Specialist with Kentucky State University. I am also a realtor by trade. Before we dive too deep into the presentation as well, I do want to give you all a disclaimer that I am not a licensed attorney, but I can give you all an overview about how heirs properties impacts you, as well as give you some sound advice for estate, as well as succession planning for those of you who are impacted by heirs property. And another thing I will say, because this is going to be more of a discussion today, I will say that as we have a discussion amongst the group, please, if you use any examples, don't use personal examples, right? Because sometimes when we have different workshops out in the public and things of that nature, there are people who are predatory, who may be trying to take your information or figure out a way to take your land. So can we all do a thumbs up if you all agree with those things? Cool, cool. So we're gonna do a quick icebreaker. Do I have sound on this, Elias? On this one? Cool. Oops. Okay. So we're gonna do an icebreaker called "That's Me." So when I make a statement, I'm gonna give you a statement, and if you think it applies to you, you're gonna say, "That's me." You ready? All right. So the first thing is, I am in Kentucky. Okay. The second statement is, I am at the Small Farms Conference. Okay. My next thing is, I have lived in only one state my whole life. Okay. So I hear a smaller amount of people. The next statement is, I have lived in another country. That's me. Okay. I have driven a tractor. Ooh, almost the whole room spoke up. The farmers in the building. I have cooked for more than 20 people. I am the baby of the family. I am the oldest child in the family. I am a middle child. It seemed like it was a smaller group of people. Okay, no problem. That's family dynamics, right? You hear the family dynamics kind of circulating in the room right now. I am a farmer. Okay. I am at least a third-generation landowner in some shape or form. Ooh, okay. I am connected to my family. I have ridden in a hot air balloon. Okay. I like roller coasters. Okay. I like a good watermelon. Oh, the whole room lit up. All right, so here are some more serious questions, and I really want to hear it. I am deeply concerned about heirs properties. I know someone who has lost heirs property land. My family has lost heirs property land. Okay, all right. Well, thank you. Give yourselves a round. Okay. So, I'm going to dive into the presentation here. Can I click forward? Let's see. Okay, So this is a question. I want to hear those numbers and figures out and see what you all think. What percentage of people do you think died without a will? Can I hear it? I heard 35, 60, 75, 95, 90. Okay. So, and I looked at two different sources for this. One source that I looked at was, and the font is kind of small. Excuse me if you all can't see it. But according to AARP, 51% of people over the age of 50 died without a will, which is intestate. By the show of hands, how many of y'all are familiar with intestate, with the meaning of that? So we'll dive deep into that here in a second. The second source that I looked at was the Pew Research Center. And according to their data, that's about every 3 in 10 U.S. adults that at least have a will. So that means only 32% of folks even have a will. Says that they have a will according to the survey and research that they did. So with that being said, after knowing this fact and data that you see, how many people would you say now died without a will? Yep, so about 68%, right? So 32% said that they have created a will. About 31% say that they have a living will, or just instructions for advanced health care directives. So like the power of attorney. But well, you don't have to raise your hand, but I will. How many of you, by the show of hands, have a power of attorney? That's me. Right? That's me. So you definitely want to make sure you have those directives in place. I've even been having some discussions with some family members of mine, I won't say who, but just to ensure now that they're approaching that retirement age and they've been working their whole lives, that they have some power of attorney directives in place. And like I said before, roughly 68% do not have a will, including myself. So I need to prepare for that, especially with my young people and children. I know, right? So, what's that? Oh, that's a great question. Can you tell me what you know commonly about a trust? Let's open it up.
Okay, what I know about a trust is they cannot sue you as a person, and they cannot search you and see what assets you have, because it's all in a trust. And you can pick who that trust goes to, and that person owns the trust. I'm a believer in trusts. Because, okay, I will also tell you, on wills, they can probate. So who wins in probate?
Can I ask the question again?
Who wins in a probates? The attorneys. And you hear of farms where family that have had major assets, and the attorney, and it's in the court and probate, and the children, the heirs, don't get anything because they weren't educated in that area. And the attorneys are the ones that pocket the money, and the heirs don't get anything. So I'm a believer in trusts.
And thank you for mentioning that. So I will say from experience, because I've helped my family members navigate a lot with heirs properties for the past 10 years, actually. And so, for one thing, as you mentioned earlier about the attorneys pocketing money in the probate process, when you think about a lot of your rural counties, right, how many practitioners of heirs property or estate planners are there really in a rural town most of the time, right? So it's kind of like when you go to the doctor. The same thing that applies to law. You may have a general attorney, attorney practicing law, but they may not be well versed when it comes to estate planning. So after this presentation, I would like to send you all different questions that you can ask attorneys to kind of vet them through that process. If you decide to consult with an attorney or hire one as it relates to estate planning or to developing a simple will. And also sometimes when grandparents or our ancestors or whoever else writes a will, sometimes they create heirs property and how they write it. So, for example, I've been having a lot of discussions with folks about wills. So let's say, for example, if I were to write one and I put in that will that I would like to divide all of my assets evenly amongst my 3 children, what do you think that creates? Heirs property. Now, why do you say that? Can we open the floor? Why do you think it creates heirs property? And there's no right or wrong.
Yeah, I think one of the things that a lot of people, especially parents, who believe they love their children all equally, and tell the truth, parents, you don't. You got a favorite. We all got one. But we try to be fair by our children, and we put all of their names on the property. They all get a little piece of land. They all get a little piece of the house and whatnot, but that's probably the worst thing you can do.
So a little bit earlier, I think we went around, and I only had a few copies, maybe about 50 copies, but I put a copy of an estate planning worksheet on everybody's table, and I can send this out digitally as well after this particular workshop. But this kind of just asks you different questions, right? And it has like a Likert scale, like where it basically asks you, taking pressure off family members about your life decisions, having a plan for your children's care, and so on. And I think on the backside, it talks about, working with attorney, how much resources you may have, if you plan on doing a handwriting will, if you plan on using an online template. And then you can even kind of brainstorm. I think there's a question on there. I don't really see it. But you could even indicate who you would plan to be like an executor or executress of your estate, right? Because a lot of times if you decide to write a will, it's a good idea to indicate who would be able to sell your assets rather than creating the heirs property that we were talking about earlier with just saying that you want your assets divided evenly amongst your kids, right? So, and also with your will, you have to be very specific because you can't really divide a property in 3, right? Like one single house, you can't divide that in 3, but you could divide it within a trust and make sure that everybody gets their fractional interest and they have an operational agreement along within that trust, right? But like we were talking about earlier, heirs property is real estate or real property that's passed along to family members, especially by someone who has died intestate or without a will. And I know specifically with Kentucky, their intestate laws follow the dower and courtesy laws. So in other words, if a mother or a father passes away, the spouse gets 50% interest within that estate, but also the children get the other 50%, right? How many of y'all are familiar with that by the show of hands? So a few people, okay. Now every state is different, and I'm talking about specifically Kentucky in this point in time. But some states, I know for example, Kentucky also does not recognize the Uniform Partition Heir Properties Act. How many of you all have heard of that by the show of hands? The Uniform Partition Heir Properties Act. So that's like a federal law that kind of prevents different corporations and other people from forcing a sale, like a judicial or auction sale, without giving the original heirs the first right of refusal. So Kentucky, for example, doesn't utilize the Uniform Partition Heir Properties Act. But there are around 21 states. Do I have a diagram? Which I'll get to later, but I'll come back to that thought. But my next question for you all is, how many acres of land do you think African Americans have lost? Throw them out there, numbers. Millions? Okay. She said 90%. What did you say? Okay. Yep, so since 1910, rural African American farm families, and this is from the 2022 agriculture census data, because they release it every 5 years. But according to the data that they released, since 1910, rural African American farms have lost between 16 to 19 million acres. That's a lot of acreage gone, isn't it? But wanted to share that with you all. So I guess my question for the crowd is, how can we prevent that? We talked about trust. I guess I didn't even talk about what types of trust, which I didn't put in here, but there are different types of trust, right? You have an irrevocable trust, where it's kind of hard to make those changes once you make that decision. But you also have what you call a revocable trust. Let's say if I wanted to disinherit someone who I thought was still the wealth from the family, right? I may have to revoke those rights from that particular individual. Let's say if, especially for some of my aged or elders in the room, let's say if you plan on going into a retirement facility, sometimes they have what you call the look-back period. So you may want to utilize your option of what type of trust and when you establish that as well before you go into the retirement facility. So there's a lot of implications also when it comes to trust that you have to think about. Question, yes, sir. And please feel free to ask them.
A trust is extremely important as you are discussing, but wouldn't you also say that a survey is also equally important? Because that's how a lot of people lose land. If they don't have a survey and they don't know what they own, somebody could encroach upon their land and make their own survey and make part of your land their land.
What about in the courthouse where you're on the books?
Let's ask it. Let the crowd hear it too. I think this is all learning for all of us.
At the courthouse, when you, your deed, doesn't it say or have some type of outline of your property lines?
Well, are you asking him the question or are you asking me the question? Because he prefaced anything he had to say by letting you know that he's not an attorney, and I'd have to stand by that same rule of engagement.
What's your answer?
So for because I'm also a realtor by trade, so I've closed different deals. But what I've seen from my practice as a realtor is when you look at the deeds that are recorded in the courthouse. Let's say if somebody files a new deed in the courthouse, what happens then? I don't really think at the land records office they're really verifying a lot of things, so it's important to pay attention as well. There is a lot of fraud, right? So when I look at data from the National Association of Realtors, they said that it's a 61% increase in title fraud. That's title fraud that it happens, trust me. So my point is, just because it's recorded at the courthouse doesn't mean somebody isn't encroaching.
On the TV, you see this commercial now. They had that pretty young lady, and they're talking about fraud and how easy it is to do a quick deed claim, that type of thing. My question is, the law says we do the deeds, we take them to the courthouse. Aren't they liable when other people take stuff from us like that?
Can you ask that one more time?
Who's liable legally when you get robbed like that?
So most of the time when people acquire property, that's why it's important to purchase title insurance, right? So a lot of people don't pay for it. For example, when I work with a lot of clients, I always advise them to pay or to purchase title insurance because it's a one-time fee. Like you're saving yourself millions of dollars by purchasing title insurance, right? Like if that fraudulent activity happens, that's when you come after a company like Chicago Title Insurance or But I guess that's also why it is important to clear up title to a property anyways, so you're able to borrow from the property and carry title insurance on it. Okay. Say that again.
When you buy or sell a place, don't you go through a title company to begin with? No, you gotta pay for that. Well, okay. You gotta pay for that. Even when if you're selling a house.
Don't pay for that. They ain't gonna give that to you just automatic.
Okay.
So to answer your question about the title company, typically, when deals are closed, the buyer chooses the title company to run it through, if that makes sense. And a title, for one, depending on what type of lender that they're using, would require them to carry title insurance. But let's say if you're a cash buyer, right, and you put your money where your mouth is, you may not necessarily carry title insurance. Let's let my lady here come, and I'll come over there.
Just real quick, I have a client through our transition program that has just that case. She paid cash for her farm from out of state, didn't do title insurance, and she's dealing with an heirs property neighbor, 8 kids, fighting over granddaddy's land, and now encroaching on their land. When they went to put the fence up for her cattle, 3 of the kids are saying, no, that's granddaddy's side right there. So they've got a big strip of grass there with stakes from the neighbor, stakes from her, where she knows her land is by acreage. They've been to court. It's a disaster. She's paying so much money. Court, and still, now they both have to get their own surveys. The surveyors in Kentucky are allowed to, they will put the line where you say, because you are their client, where you say that line is. So it's really still in the same situation. And the surveyor that they spoke to, that came for the neighbor, he called and spoke to her for some reason, and she said, so what did you see? And he said, well, I agree with where you say your line is, but I'm surveying for them, so I'm putting the line where they want it because I work for them. And I asked her, did you have that conversation recorded, which, by the way, in the state of Kentucky is not illegal to record a phone call. So anytime you're talking to someone, get a little recorder on your phone, which you can get an app to do that. But she said, I had no idea I could even record phone calls. I said, you're in Kentucky. You can record any conversations. And if she had had that, she could have took that to the court with her, and it would have been a good piece of evidence as well. But instead now, they've got to go further into court and have, I guess maybe the courts are going to issue a surveyor out, but it's just back and forth, back and forth. So get the insurance every time. And yeah, that's all.
Yeah, absolutely, because you want to protect your investment. Mr. Coleman, did you have your hand up? Yes, sir.
Mr. Shavis is going to like what I've got to share. I'm Jim Coleman. I'm in Lexington, and I purchased my family farm in 2001, and my parents owned it. They were third-generation owners, and I'm the black sheep in the family. When you buy land and you're the one that buys it, you're considering stealing it from everybody else because they can't afford to buy it. So I came back home. I assumed the mortgage that my mother had on it. She made that available to everybody. I'm the only one that took her up on it. And my goal was to fly into town from New York and get back to New York in the same day. So I was ready to sign whatever papers, get this thing, and to duck and get out of town. So I signed the papers. Fast forward 2020, I moved back home, and I'm ready to build a house on the farm that I've owned since 2001. The builder said, Mr. Coleman, we're going to start next week. I just need to go down to the courthouse to get a survey and a plat. I said, okay, go on and get it. He called me that evening after he went down to the courthouse. He said, we got a problem. I said, what's the problem? He said, you don't have a survey on your farm. Y'all, that was scary. That was scary. I didn't know, it was after 5. I couldn't catch up with my lawyer to find out what does the deed say. I felt ignorant, stupid for not knowing that. But I found out that I had purchased a farm my family had owned, but it was in 4 different parcels with a lot of different names on it. Now, fortunately, my parents had that all transferred and combined, but I didn't have a survey or a plat, and that cost about $3,000 to get that done. But I do recommend, just for your own protection, is to get a survey for your land, that if you own it straight out, check to make sure it's not, because my farm was a quilt, and I basically turned it into one blanket by having that official survey and plat. So I encourage you all to do that.
Thank you for that. So a little bit earlier, are there any other questions before I go forward or comments? Okay.
I just wanted to rewind back to trust. Everybody's talking about generational wealth and transferring this and that down generations. People don't even know how much trust costs, right? It's conversation. I mean, some are even more. 10,000. Nobody's talking about that. So.
Yeah. So there is a cost to establishing a trust. From what I hear is, and correct me if I'm wrong, I don't think I am, but there are, a person can be a trustee of their own trust. Have you all heard of that? Yeah. So, you can establish those rules, but also it's a good idea to go through a licensed attorney to make a trustworthy licensed attorney, not just any attorney, right? I think it is important to vet attorneys, which I'll share a little bit later as well.
And when you pick your trust, like I've got a trust and I've got 2 trustees, and just please make sure that those trustees are competent. That, it could be your cousin, it could be your brother, but get out of the personal side and can they count? Can they do things on time? Will they get you, when they hear that you died, we are all going to die. Nobody likes to hear that, but I've gotten used to it. Can they handle it, or are they going to flip out? Are they going to get intimidated? Because a lot of my family members are going to try to intimidate the trustees that I've selected. And do they have the spine and backbone to be able to do what I have in my will and my trust? So it's the 2 that I've got, I love them. But just since in the last 4 years, I've watched their behavior. I love them to death. But I just had this meeting with my attorney last week. I'm going to make changes because I love them, but they're just not able. They don't have the strength to take on the battle that they're going to have to deal with when somebody calls them and say, he's dead. Okay, so make sure whoever you pick, even if it's your lawyer, it does not have to be a family member. Preferably if it's your accountant or your lawyer and you can trust them and they're competent. That's what you want.
Yeah, see, that's that revocable trust that we were talking about a little bit earlier too. Like sometimes it could change. Okay? And I'll come over here too as well, okay? Oh, okay. No problem.
This is for Jim Coleman. What's the advantage of having 2 trustees?
Set up to where when my estate, I'm going to have it dissolved so that I can leave a trust to be able to provide money to 2 institutions, 2 colleges that I've put in my will that my wife and I want to support in perpetuity. So you just want to make sure that the court sale on any of your assets, including your land, that it's done properly. Even again, if you trust your trustees, you want to have it to where it has to be approved by the court, the judge, on the price that it was. So as an example, if your farm today is worth $500,000, you do not want a trustee selling it for $100,000 to their nephew and they take it.
Right.
So you want that sale to be approved by the court based on a fair appraised value, so that that nets into the estate fund that you have dedicated to whatever cause you have. I mean, it's a lot of things.
Wait a
it's
minute
a lot
now.
of worries.
As property, the value increase, do you have to go back?
No, it's all handled at your death. And that's why you want to have a good trustee and a good lawyer that at that time, I want it to be where we get 3 appraisals, take an average of the 3, and that's where the market starts. Because I've got some plans that I've set up to be able to fund certain organizations that I have in my will from the proceeds of that sale. So if it's worth, hopefully I live another 20 years. In Fayette County, let's say it's 2.5 or $3 million. I do not want my trustee to sell it for $200,000 to a family member and pocket. You just get to, when you get down to the facts, anybody when it comes to money can do wrong. That's the bottom line. So you want to have it to where you've got a lot of eyes looking, and that's why I've got the court and the judge in Fayette County will have to make the final approval on the sale of my land before it gets transferred. It can't transfer and then later on find out it was worth $2 million and it was sold for $300,000. Does that make sense? So you can put that clause in there, and your lawyer, your state lawyer, can back that up.
Okay, thank you.
My estate lawyer right now, he had to go to the hospital this week. I rushed to the hospital. When he called me, he said, man, I'm sick. He had emergency surgery. I don't go to the hospital on emergency for a lot of folks, but he is important to me. And he just sent me a message. It's amazing. Just today, I've been discharged. That's a relief. I told him, do not die until I die, because I trust him. I trust, and it's hard to find people that you can trust when it comes to money. Just, it ain't playing. It ain't playing. A lot of people can't handle it.
Well, Jim, would you advise one legal person and then one family member? Would that work?
Just go with a qualified trustee. Don't even think about family. Take the word family out of it. It's nothing personal. Like on The Godfather, it's nothing personal, Sonny. It's strictly business. If it's a family member who happens to, if the trustee happens to be a family member, that's fine, if you trust them. But you don't need to have a trustee and some family member that's emotional, that doesn't understand what you want, and that will execute what you want. So it comes down to competence and trust. Can you trust this person? Have they displayed an ability to be mature? Can they handle stress? One of them I'm going to be taking off, and I think she's smart as she can be, but I've seen her just in the last 2 years where she gets a little thrown off, which when I die, it's going to be, I hope a lot of people are going to be sad, and she will probably be too, but when people are sad, they make bad decisions and can be taken advantage of. So you want somebody that can step in and say, he's dead, here's what he wanted, here's what we're going to do.
First year, yeah.
Yeah, here's what the trust says, he's dead, and here's what we're going to do.
6 months.
Well, who are you? I'm the trust. It says right here, it's authorized right here with his notary, I'm the boss. Well, who made you but you ain't even a Coleman. He said right here on this date, it's notarized with the lawyer right there. Otherwise, people will go crazy. Isn't that right, sister?
So by the show of hands, how many of you all would like for me to send you different questions for you to vet attorneys? Because I do have a list of questions and of resources that I could share out with everybody in this room. Because I do think it's important to vet your attorney. Some of the stuff you could do on your own, but you really want a licensed, qualified attorney to handle some of those situations. The whole point of this educational process is really to get you to make different decisions and prepare for your meeting with the attorney, right? Like if you do a lot of that legwork of who you want to leave your assets to, you've done 90% of the work. The attorney is just the person that's going to overlook everything that you've done within your estate plan. So I really would like to schedule different seminars and workshops after this to address some of those things to get you all really thinking about estate and succession planning, especially for my farmers in here, right, who have businesses, business entities. You really want to develop those plans and move forward and prepare for that meeting with your estate attorney. Were there other questions? I saw a couple of hands in the room too.
Yeah, anybody else?
Our farm is incorporated, and we have roughly about 35 shareholders. We have a shareholders agreement. Does that shareholders agreement override a will or a trust? Because in the shareholders agreement, number one, their shares can only go to family. And there was one other thing I forgot. But anyway, in relation to a will or a trust, does the shareholders agreement hold up?
From what I've noticed with corporations, normally they have bylaws, for one, right? They have bylaws. So to answer your question, I think it's all intertwined within that trust. But I would say another thing with corporations, along with those bylaws and stakeholders, before you can move forward, is voting rights. So like they have to vote on certain things before you can make particular moves, depending on which stakeholder has the heaviest percentage or the highest percentage holds the most weight too, right? So I do think that's the advantage of a corporation.
Shareholders agreement and the person's will don't agree as far as the property. Does the shareholders agreement take precedence over the person's will?
Can you ask that one more time?
If the shareholders agreement says one thing and the person's will says another as far as what's to happen with the property, does that shareholders agreement, because we're incorporated, take precedence over the person's will? Or can it, if we say in there that in the event of death, that this X, Y, and Z will happen to the property in the shareholders agreement, but the person who passed had something else? Which would work?
I'm not really sure on that one. That's a tough one to answer. Yeah, that's a tough one for me to answer. I would say if the person has a will, are they the sole owner of the corporation? Do they have any decision-making power as far as the person that has the will? Yeah, so if they have a succession, if they have like a strong succession plan in place, and they have a percentage of power, like let's say if that person that has a will has a 30% voting, of 30% stake within that corporation, that would be passed down if they do it properly to their children. Am I making sense, or? Okay. Because I don't really want to use too many personal examples, because everybody's situation is going to be different in this room as well.
Hello, I was just going to add to that because recently my father passed away, and so some of those estate things came up, and he had a couple of legal layers. And one of the things that I learned is depending on the laws at the time, so even addressing about the will and those kinds of things, it's really going to depend on what the law is in each jurisdiction. And then also like how the law is going to affect during the time that the will or said entity was developed at that time. So if it was developed in 1980 versus 2025, the laws may have changed. That's one of the things that I was advised was with the estate and estate planning and all of those kinds of things is you really want to, as Casey was talking about, Mr. Townsend was talking about, working with an attorney, as Mr. Coleman was talking about, because the laws can change. So it might have been established during this time period and the laws were applicable, but then later on they may adjust, and then not just waiting until that time, but periodically going and checking with your said attorney or legal official.
And I would also say, depending on which county you're in too, like you were talking about. So for example, and I'm just using it, but the probate process in Franklin County might be different than the probate process in Fayette County, for example. So those are some things to take note too, is looking over those probate processes depending on which county and state that you live in or where the real property is located, becoming well-versed in what those processes would look like for you. When it comes to developing your will, that can impact how you move forward as well. Okay. You got it?
Isn't it that most black families are losing their property because of taxation? Because in the community I'm from, we can't pay the taxes. The city values the land so high, it's not even worth it. So you got a piece of property, but the city has valued it, so it may be a piece of property, a few $1,000s, and then the city makes it taxation. That's the way of getting black people to lose land. The taxation gets really high. for example, in this community I'm from, the whole community is like that. Taxations. And it's not worth it.
I think also because I think a lot of people in this room are probably. You want to go first? You good? You can go ahead.
That's been going on for a long time. Our family has owned that property since 4-digit numbers, and many of those people moved there together. And one of the things that the city will do is come cut your grass for $200, but they cut it only to 6 inches, to where they have to come back and cut it again. And so now you have people that don't have heirs and can't fix up the property, and that's how gentrification occurs. So now that property is taken for eminent domain, and it's now 5 times more than what was being paid, and that happens far too often. Oh, I did have another question, though.
Go ahead.
Okay, so similar situation. My father passed a year ago today.
Personal examples, though.
Well, so I have a question with that.
Okay.
So there was a fraudulent will that was bought, but we have a POA, and the POA has been standing for the past 2 years. So which one wins out?
Which state are you referring to?
In Virginia.
So the state of Virginia. Now I can send you some resources of
Yes,
different
please.
heirs property laws that they have, because this is also a presentation with the Southern Regional Development Center, and so it's a conglomerate of us like doing research about this topic, and they have a lot of those situations that you're talking about with different infographics for Virginia, for Vermont, for Maryland, for North Carolina, for Kentucky is another one, where they have different steps that you could go about with dealing with fraudulent titles and things of that nature. So please, for everybody who are looking for resources from us, please, I think I put a survey out, and at the end of the presentation, you'll see it as well, so I can get your contact information and share whatever resources that you're looking for. Because everybody in this room is going to be looking for different things and different resources for support. But I think we were talking about the heirs property or as far as tax liens. That's what Dr. Dawson was talking about earlier with tax liens. A lot of times that happens because a lot of the heirs really don't decide on who's going to handle the payment of the taxes, right? and then if you never really reach an agreement, how can you contest what they have assessed the property for? Because sometimes they can assess it, like for example, that it's a $250,000 house when really the house is worth 70 or 80K. So you can contest how much they have indicated that the tax value is as well. Yes, sir.
Is it good to have revocable trusts?
I think it's just dependent on what age and stage you are in your life, and how many trustworthy family members that you have within your family. I think each situation is going to be different. And the reason why I say that is, so for example, let's say, and I guess I could use this as an example, my Aunt Sadie, right? She died at 88. She didn't have any children. She only has one other sibling that lives in California. So, which kind of trust might be good for her, right? Like, it's only so many people that she could pass her assets on to. So you have to keep that in mind as well. Like, who do I have? And is it the church that I leave? Some people leave their trust to their churches or to charitable organizations as well. So I think it's all contingent upon what your situation is in life. Does that make sense? Am I rambling?
Funny business, when I die, that I want Torch to be taken care of, first class. She's used to being taken good care of. I'm not going to have her high class one day, ghetto next. So my lawyer is going to put together a pet trust for Torch that's going to be able to have their current breeder that I bought her from, to have it to where for 15 years, Torch will, there'll be a certain amount each year paid to the breeder and food and everything that Torch needs, veterinary care, for 15 years to make sure Torch is taken care of. Yeah, we got to be down to that. But that is hot, and that just happened in the state of Kentucky to be able to have a pet trust. We were one of the last states in the union to allow that. But today, we can't even have a pet trust. As far as revocable, I think revocable is the best way because things change, relationships change. Your focus and caring about different organizations and what you want to do with your estate, that changes. So you want it to be permanent just in case you could die at any moment, but you also want the flexibility that if, over the next 10 years, if things change or on an annual basis things change and you want to direct it, you have that flexibility.
Yeah, I actually had a conversation with a colleague of mine about an irrevocable trust at one point too, especially since the lady was much older. She was about 78, and I explained to her about the instrument of a revocable trust, but she was like, "Well, nah, my decision is final. I'm not falling out with my kids, so it's going to be an irrevocable trust because I don't know how much longer I have." So sometimes it just fit upon your situation too. But revocable is always like the most stable one, just in case something does change. But if you just make that strong decision, sometimes people will still choose an irrevocable one too.
If you owe money to somebody, can they go after you die or before you die? Can they go over the revocable trust?
Well, from my understanding, that's the whole point of the trust instrument is to protect your personal assets. So, for example, if a person owes medical bills, right? Like if a person is died of old age or, died for unforeseen circumstances, really they're suing that individual for those medical expenses personally. But if it's in a trust, the trust is the instrument that protects the individual's personal assets. That's the whole point.
Even before you die, an accident or something, and they're going to go after your property.
Well, there is a look back period. Remember, I don't know if I mentioned that early on. There is a look back period depending on when you establish the trust in certain situations. So they probably could, depending. I don't know. I have to get back to you on that. I would have to get back to you on that. But people use each instrument for different reasons, right? Because let's say if my mom was retiring and knows that, she's trying to plan for her retirement and also pass assets on to me, but she plans on being in a retirement facility. The question is, when does she establish that trust? Whether it's irrevocable or revocable, when does she establish it? Because Uncle Sam also looks at when you establish it too, right? Depending on how you set up your taxes and Social Security and so on, right? If I'm going to be depending on Medicare and things of that nature, it's almost as if you're getting certain government assistance. They want to know what assets you had before that. Does that make sense? They do look back. Maybe 5 years, sometimes 3 years, depending on the state.
This goes back to taxes. Let's say the land is divided into 4 plots, and 2 of the people move out of state. They don't pay any attention to the land for 20 years. The other people are paying the taxes on the land. Does that land automatically belong to the people paying the taxes after a period of time?
I know somebody, I won't say who, but I know someone who has experienced that. But I do think it's important to maintain those tax records. Like, I do think you have to have strong tax records showing like accounting principles as far as where you paid those taxes from, the original receipts, and even the who, like as far as who paid it, what the amount was for, when. I think you want to have all of the information, but it can be possible. Yeah, it is.
Yeah, we kind of going through something like that now, because like I say, my grandfather, he was taking care of this land, paying all the taxes. Now he's deceased. Then my father took over, and now my father's deceased. Now we paying it. So it was 2 tracks. It's a journey to my grandfather's land, but we've been taking care of the taxes, the upkeeping. But I called this county attorney, and the term he said was adverse possession. That term is adverse possession. It says that a person that's been taking care of the upkeeping of the land, paying the taxes, they can be that land can get awarded to them. But you'll probably have to go through, get an attorney, get a real estate attorney, because they know that terminology. They can measure and do all this. That's kind of what we're going through right now. But I heard the term was called adverse possession. Because you paying the taxes, keeping the upkeeping, because they said you paying the taxes and the wear and tear on your machine and the gasoline you paying, it should be awarded to you.
And you also be careful and let people do all that on your property for that reason too, because they can take it. I'm sorry, I've been around.
Yeah, she was just talking about pretty much encroachment, right? So when you notice somebody is encroaching on your land, so for example, if I built a fence on my neighbor's property line and she doesn't address it after a certain amount of time, I'm encroaching over her land, and I could then make that property mine if she doesn't address it, especially if I got it resurveyed, like we were talking about with surveying, and she didn't say anything after. I think in Kentucky it's like 7 years too. I think it's 7 years. So if you don't address that and go without saying something, it could get pretty nasty.
Thank you. And that brought up another thing, is being careful about what attorney you work with, and knowing who to go to. So when somebody passes, and again, this is just personal experience as well as some training, but my father had a trust. He had a will. There was property, there was estate, there was a probate attorney. And so in going to the trust attorney knew a little bit about the probate, but in the end, it really needed to be a probate attorney. And that's something else to keep in mind when you're developing your wills, developing your trust, developing your succession planning, if you will, is what types of attorneys are for what. And it's kind of like with going to a doctor. You may have your primary care physician who's a family doctor or an internist, and they might be able to help you with your foot. But ultimately, you may need to go to a podiatrist in order to really get down to the root of the problem and really get it healing and getting all of that done. So it's very similar with the attorneys that you get. So whenever you're working through it, being sure that you speak with the right attorney, because it's not so much that the attorney doesn't care, but they may not know exactly all the fine-tuned details. And like we were talking about, it'll depend on the time, the state, the county, and like with the time limit on, the 7 years versus 5 years versus whenever. So just being careful with that.
Also, I might make some suggestions that will be helpful. And most of the times, it's very helpful to have a clear survey of your property with the survey pins in place and a good fence around your property. And when you get that good, clear survey of your property, make sure that that survey is recorded in the courthouse and stamped by a licensed surveyor. Otherwise, you may lose your property. And in the case of taxes, I have noticed that one time I had a piece of property, Heirs property, and there are a bunch of people that hang around the courthouse to see if you don't pay your taxes. They will pay those taxes and do it for several years. Now, if you don't pay that person that's done that to you, and they can give you a bill for that, plus they add interest to it. And if you don't pay them, they'll wind up getting your property after a certain number of years. But you have to pay your taxes. and make sure that your property is surveyed and recorded in that county where the property is located. And it should be done by a licensed surveyor with his name and his stamp and his number on it, so that it cannot be contested, because there are state laws regulating that.
Yes, sir. Thank you for that. We got about 6 minutes left. And thank you, Mr. Thomas, since you mentioned something about heirs property. I did pass out a sheet at your tables that talk about establishing by the show of hands, how many of you all have a family tree? You'll be surprised, many people don't. I think that's a good step to start with. I always advise a lot of clients that I've worked with in the past, whenever you're trying to, let me go back. Whenever you're trying to establish or first start the heir property process with identifying who owns a fractional interest, it's a good idea to start with a family tree. So I do have a handout there and can email you a copy of that if you want a copy of it. But I think that's a good start. Also, notating the date, that if people have passed away, notating the date that someone has passed. Also, if someone does pass within that family tree, identify their offspring as far as their descendants as well. So you want to identify it from the top of the tree down to who is living, right? So you don't necessarily have to go beyond the person that is living, because it stops at the fractional interest stops at the person that is living. So keep that in mind. And there are websites where you can digitize your family tree. I do think that's really important to have a copy of. Some of you can use what you call, Ancestry.com. They have like a digital version. You could use a free trial and develop that family tree. Now, you can also get other records, which a lot of people do, from the probate office. You can almost identify which heirs may be involved with the property from the land records office. Some people call it land records. Some people call it property value administrator, depending on which county it's located in, or the land records. But you can get those individuals' names, sometimes phone numbers, and even mailing address. That's important as well when you're trying to clear a title or a deed for a property. So I wanted to mention that. How many of y'all are familiar with the relending program for heirs property to the USDA? By the show of hands. Yes, how many of you all are familiar with the relending program through the USDA? It's called an heirs property relending program. So that could be a strategy to clear up a title or a deed issue for those folks who are trying to buy out fractional interest. But it does require a succession plan, which is why I want to discuss, especially with a lot of my farm owners in here today. If you do have title issues and you are able to identify those heirs with the family tree, you could look into doing the relending program. And I think within that program, the interest to borrow that money is like 1%. So it's a very low interest loan, and it's a good strategy to, especially if everybody is on board and you know who the heirs are. However, you have to buy them out, unfortunately. This could be a good tool and strategy for you to clear up the deed and title issues. So I believe your question was, would that pay for the taxes? I'm not sure. I'm not sure about the taxes. Normally, you want to maintain the taxes up until the time you try to close. And I think normally that's what creates heirs property. Excuse me. I think normally that's what creates heirs property, is for the fact that a lot of folks are unclear with whose responsibility it is to to pay the taxes. But if you're interested and you have the resources, I would always say just pay it and keep a record of it. And even if the taxes are too high, you can always contest it. But we're running out of time here. Okay.
I have a USDA loan for my farm, and my taxes are not included in the payment, and I don't think they do that with any of their loans, but I'm not sure, but don't quote me on it, but they're outside. But also the Ancestry.com, you can get a free Ancestry.com access with your library in Fayette County. I know we have that, so that's another source. If you go to the library, you can use Ancestry all you want. My mom does genealogy.
But normally when you get a mortgage in general, normally they do what you call PITI, which is your principal balance, your interest, taxes, and insurance. So you can get your mortgage set up in that way after the closing, right? So like once you acquire the property, they do what you call PITI. Principal, can y'all say it with me? Principal, interest, taxes, and what else? Insurance. Yep. So to answer your question, no, they normally don't include the taxes, now that I think about it. Uniform Partition of Heirs Property Act, that's the act that I was mentioning earlier, where the corporations can't force a sale without identifying the heirs and giving them an opportunity to acquire the property. Kentucky is not one of those states, but there are 21 states currently that's negotiating or trying to enact the Uniform Partition Heir Properties Act. And my home state, North Carolina, finally will be enacting that law this year of 2026. So it is a big deal especially like in places like Arkansas. I wish I had enough time to show y'all the video, but in places like Arkansas and even in Kentucky, when people identify who the heirs are and they buy out their fractional interest, they force the sale, and that's how they normally take the land. But this particular law, they're able to protect, right, their family land. So those are the benefits of it, for the fact that you prevent the automatic partition, right, especially if a corporation owns 20 or more %, prevents unnecessary loss of ownership of all the heirs. So I do like the fact that they're given that first right of refusal. So for all my Kentucky folks, reach out to your legislators and see if they could really advocate to pass this particular uniform law. And then of course, form numbers, reaching out to your local Farm Service Agency. Especially if you're trying to do the relending program, it's almost as if they want you to already have a succession plan in place where you're actively already farming. That can be an advantage for folks who are trying to handle heirs property issues, but it can also be an issue if you haven't already established it. This is just the same survey that I have out, so before I think we end right at 2, right? We're past time, right? Okay. So please, y'all, feel free to scan this QR code or fill out the hard copy at your table so I can stay in touch with you all. And that way I can send out any information that you might be looking for, as well as figure out which counties that you might want to see more workshops, more in depth, because it's kind of hard to cover all of this information in 45 minutes to an hour. So I would like to hear from you all and maybe come out to your counties and schedule some more in-depth workshops if I could. Yes. I wish I could scan that. Yeah, so if you scan it, my contact information, can I just tell you all? I'm surprised I didn't put it up there. Yep, so it does come up at the beginning of the survey. But my name is Casey with a C, C-A-S-E-Y, Townsend, and that's TOWNSEND, the number 1 at kysu.edu. And that's my my email. And then the phone number is the area code 502-597-6417. But yes, please, I will follow up, I promise you, with each and every one of you if you take the survey. That way I can follow up with you via email or even a phone call. But there's also, if you don't have a phone, there is a hard copy, and I could come around and grab it from your tables as well. Did anybody have any other questions or comments before we go? Okay. Can I hand you that?
Yes.
Yes, sir.
Have you ever heard when you become a certain age that you don't have to pay property taxes?
That's called the Homestead Act. So I always tell, like, for my folks, I believe it's like once you turn 65, they have what you call the Homestead Act. Yep, so it lowers your taxes. I have a friend that just, my friend Dan, they got super excited when he turned 65. He said, Casey, I only got to pay 33% of what my actual taxable value is due to the Homestead Act. So to answer your question, yes. Yes. One time. So as soon as you approach the age of 65, or if you haven't thought about it, but the deed does have to be in your name. The deed does have to be in your name, and the Homestead Act only applies to your residential property. So it doesn't really apply to your LLC or your business. It only applies to your your primary residence. Any other questions? Well, thank y'all so much for y'all time. I really appreciate y'all. And if you have the sheep, can y'all please stick them up high, and I'll come around and grab them. All right. Thank you. Appreciate you. Man, I can't believe I saw you today, man.
Congratulations.
Yes, sir.
You give a good client.
I appreciate it.
Yeah,
I appreciate it.
It's all right.
Yes, sir.
It's all right.
Oh, thank you so much.
Thank you.
Yes. I look forward to having more conversation, too, with you.